Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. I want to talk a little bit about visitation rights for a non-custodial parent. It's a little bit of a redundancy in that the rights of the custodial parent, well, those are not called visitation rights. Those are your custody rights. So whenever we're talking about visitation rights, we are typically going to be talking about the non-custodial parent. Now, the non-custodial parent has the opportunity to spend time with the child on a non-custodial parenting time or visitation basis. Typically, that'll mean that while the child primarily might reside with one parent, the other parent has a right to spend time with the child and visit with the child. And it could be on all sorts of different types of schedules. It could be a schedule where they alternate weekends, the parties alternate holidays. It could be a situation where one parent has the child, Monday through Friday, and then Saturday, Sunday, and return the child to school on Monday morning. The other person has the visitation. So the visitation rights are rights that the court orders. They are primarily rights that the parties should attempt to agree on, and in most cases they can. I will tell you that having run this firm for many, many years, when it comes to parenting time, the parties are typically able to work out some kind of schedule. The schedule takes into account what's good for them, what's good for the child, what makes sense for work, what makes sense for the locations where the parties live in relation to each other. These are the kind of things that the parties take into account. If you cannot work it out, though, you go to the court, and the court will likely default to its standard schedule, which may or may not take into account those factors that we discussed. Like, you may work close to each other, but your schedule may have you leaving work at 5 o'clock on Monday, Wednesday, Friday, and at 3 o'clock on Tuesday, Thursday, Saturday. So, in other words, they're not necessarily set up to take every single person's schedule into account. If you leave it up to the court, they may impose a generic schedule on you, which may not work. Or they may try as best they can to work out a structure that makes sense, specifically customized for your life situation. The court always tries to do that. But if the parties can't agree and the court is faced with two people who just don't seem to agree on anything, it's likely that the court, perhaps out of frustration, is going to say, okay, look, if you guys can't agree on how this should go, this is what I'm ordering. And once the court orders it, it may be good, it may not be good. It may be something that you can work with, it may not be. In that situation, I would say that it's very important when you're dealing with non-custodial visitation that a parent should get together and try as best as they can to work out a schedule that makes sense for them. I always feel, and I will leave you with this, it's better to even begrudgingly resolve the situation and come up with your own solution than to cast it in the hands of the court. Because in many cases, the court will somehow find a way to inconvenience both parties, and we don't want that. If you have any questions about your case, of course, reach out, and we'll be glad to help you out.